Good morning, afternoon, evening, midnight, and noon. I'm William Espy with Precedent in Motion, and today we're talking about one of the most important legal doctrines in U.S. administrative law, Chevron deference. Today, we're going to be talking about its implementation, the effects of its implementation, its eventual rejection, and how its rejection may affect us in the present and in the coming future. So, let's get right into it. Chevron deference, the evolution of a key judicial doctrine. Now, before we get into the case that actually made Chevron, let's go into the congressional and administrative backgrounds of that case. In 1977, Congress amended the 1963 Clean Air Act, making it so that way every new major stationary source of air pollution had to be approved by the Environmental Protection Agency, or the EPA as I'll be calling them. This had the purpose of reducing air pollution around the United States. In 1991, the EPA changed their interpretation of a major stationary source of air pollution from what is in the past a more minor piece of equipment such as a boiler or smokestack to an entire plant or factory in itself. From this definition, a plant or factory could add a new piece of equipment or modify a piece of equipment that made more air pollution if they also equally reduced the amount of air pollution coming from other parts of the plant. Now, later in 1981, the National Resources Defense Council, the NRDC, filed a petition to the D.C. Circuit Court of Appeals that challenged the EPA's interpretation of a major stationary source of pollution. The D.C. Circuit Court said in their majority opinion, quote, "The EPA observed that the purpose of the non-attainment provisions is to positively reduce emissions, not merely hold the emissions constant. EPA therefore concluded that the dual definition components with the purpose of Part D, or use of plant-wide definition to avoid a new source review, would appear to be inappropriate in the non-attainment areas." From this statement, the courts sided with the NRDC, basically saying that the EPA's interpretation was invalid because it went against the stated purpose of the 1977 amendment to the Clean Air Act, which was, of course, to reduce air pollution. Now, the Chevron Corporation, which was affected by this decision, decided to appeal higher, up to the Supreme Court. And this is when I get to our actual court case, Chevron versus NRDC. The Supreme Court accepted the petition, and after hearing arguments, stated in its majority opinion that, quote, "When a challenge to an agency construction of a statutory position, federal judges who have no constituency have a duty to respect legitimate policy choices made by those who do. The responsibilities for assessing the wisdom of such policy choices and resolving the struggle between the competing views of public interests are not judicial ones." This makes the court's opinion clear. The judicial branch are not policymakers for the government, and therefore should not act as such. Additionally, they reprimanded the D.C. Court of Appeals for attempting to create a new government policy in their opinion. Now, they also stated that, quote, "First, always, is the question whether Congress has directly spoken to the precise question at issue. If the intent of Congress is clear, then the end of the matter for the court, as well as for the agency, must give effect to the unambiguously expressed intent of Congress. If, however, the court determines Congress has not directly addressed the precise question at issue, the court does not simply impose its own construction of the statute. Rather, the statute is silent or ambiguous with respect to the specific issue. The question for the court is whether the agency's answer is based on a permissible construction of the statute." In this statement, they basically laid out exactly how Chevron deference would work for the next 40 years. There'd be a two-step process. First, they'd question if the law is ambiguous. If not, then the courts and agency must therefore defer to the purpose of the law and Congress. However, if the law is ambiguous, then the courts must defer to an agency's interpretation of the law if the interpretation is deemed reasonable or permissible. Chevron became one of the most cited cases and doctrines in U.S. administrative law, being present in thousands of cases and briefs. Additionally, the application of Chevron made it that way whenever a federal agency's policy related to a law was questioned, the courts almost always decided with the federal agency. Chevron also largely replaced Skidmore deference, which would be the idea that courts should respect an agency's interpretation of the law, though not necessarily always defer to it. Chevron also was in contention with the Administrative Procedures Act, or the APA, which reads, quote, "To the extent necessary to decision and when presented, the reviewing court shall decide all relevant questions of law, interpret constitutionality and statutory provisions, and determine the meaning or applicability of the terms of an agency action." Basically saying that the courts have the responsibility and ability to interpret the law to their will. There are other problems with Chevron, such as at times circuit splits between different courts as to whether a law was ambiguous or an agency's conduct was reasonable. Now again, before we go into the case that rejected Chevron, let's go into the administrative background of this case. In 1976, Congress passed the Madison-Stevens Fishery Conservation and Management Act, or MSA, which authorized the National Marine and Fisheries Service, or the MFFS, a subsidiary to the Department of Commerce, to require fishing vessels to carry federal monitors on board in order to ensure that federal agencies' policies were being followed. In 2020, the MFSS established an industry-funded monitor system in New England, although MSA did not explicitly allow them to do so. Looper Bright Enterprises, a fishing company that operates off the coast of New England, sued the MFFS for the industry-funded monitoring system, which, according to them, was not allowed through the MSA. Additionally, Relentless Inc., Hundreds Inc., and Seafree Fleet LLC, which are also fishing companies that operate off the coast of New England, also sued the Department of Commerce for the exact same reason. Now, let's look at the judicial background and issues of the cases that overturned Chevron. In Relentless, the Rhode Island District Court used Chevron deference to decide, quote, "The District Court granted summary judgment to the government. MSA is ambiguous regarding authorization for industry-paid monitors, and that under Chevron, the agency's interpretation is entitled to deference." Relentless and the other plaintiffs then took this to the First District Court of Appeals, who did affirm the lower court's decision. Relentless and the rest of the now petitioners petitioned the Supreme Court to overrule or at least limit the scope of Chevron deference, which the court accepted. In Looper's case, the D.C. Circuit Court sided with MFSS after using Chevron deference first step, citing that MSA was not ambiguous as to whether or not MSFS had the right to fund monitoring in the industry. Looper then took the case to the D.C. Court of Appeals, who held that MSA's language was ambiguous, but MFSS's interpretation was reasonable. Looper then petitioned the Supreme Court to take up its case, firstly to, quote, "Whether under proper application of Chevron, the MSA implicitly grants MFFS the power to force domestic vessels to pay the salaries of the monitors they must carry, and secondly, whether the court should overrule Chevron or at least clarify that the statutory silence concerning controversial powers expressly, but narrowing granted elsewhere in the statute does not constitute an ambiguous requiring deference to the agency." Basically, whether or not to overrule or at least limit the scope of Chevron related specifically to ambiguous statements. The court accepted the petition, but only on the second point. Supreme Court heard both Looper and Relentless's oral arguments in the same day, actually, and issued their majority statements as a pair for the two cases. In their majority decision in Looper v. Raimondo, they state, quote, "The Administrative Procedures Act requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and the courts may not defer to an agency's interpretation of the law simply because the statute is ambiguous. Chevron USA Inc. versus Natural Resources Defense Council Inc. is overruled." This majority decision clearly states that Chevron is overturned, to the shock and horror of all the administrative law professors across the United States. And largely it has been overruled because of its conflict with APA. Now, the courts did hold that less total means of deference, such as Skidmore, could be used, stating, quote, "What is usually called Skidmore deference continues to apply. Under that decision, Agency interpretations constitute a body of experience and informed judgment that may be entitled to respect. So, where does that leave us? Well, with Chevron overturned, it's likely that less total means of deference, such as Skidmore deference, will likely become much more present in cases that question a federal agency's policies. Additionally, these cases that do question or challenge a federal agency's policies will become much more prevalent and much more numerous as more people feel like they can question a federal agency due to the high standard of Chevron being totally stripped down. Additionally, we'll probably see some fragmentation in the courts, as now there's no common standard, such as there was with Chevron, as to how they should decide cases that question a federal agency. So, with all this, we'll see a rise in cases that, question federal agencies. We'll see Skidmore deference becoming the go-to for the defense, and fragmentation in the courts. Oh, and of course, all the professors that teach administrative law are crying in their beds and want a popsicle. But other than that, when all these come up and obviously cause problems, I will be there to cover it. So for today, that is it, however. So, as I always say, good morning, afternoon, evening, midnight, and noon. I'm William Espy with President in Motion, and this has been the evolution of Chevron deference.